Good morning. Welcome to our fourth session in the series presented by Pro Seniors and the Ohio Department of Aging in collaboration with the Ohio Training Advisory Committee, the Elder Law series for 2024. And today's session will be on long-term care residents' rights. Before we get started, just a couple reminders. The materials and then later the recording are all in an online folder. I will put the link to that folder in the chat in just a moment, but you can also find the link in the reminder emails and the follow-up emails. The recording should be posted by the end of the day today. If you missed part of the session or you want to let your colleagues know that they can go online and watch the recording later. We have been approved for 1.5 hours of CLE credit for this webinar. To receive CLE credit, you'll need to respond to the polling questions when they come up and also respond to the survey at the end of the session. It should pop up on your screen when we close the Zoom, but if it doesn't, we will have the link in the reminder email that goes out later today. If you have questions along the way, please feel free to put them in the chat. We will help monitor that and let Miriam know when questions come up. So with that, I will pass it over to our speaker, Miriam Sheline from Pro Seniors, to talk more about residents' rights today.
Thank you, Melissa. Good morning, everyone. Also a reminder, the next chapter, there we go. The next chapter is scheduled for 3 weeks, and that one will be May 10th, and we will talk about nursing home litigation. So that is a nice segue from what we're talking about, residents' rights, violations, etc. So with that being said, let's get started. Welcome, everyone. Glad you're with us. And I hope that this will be instructive. So there have been some major updates with regard to residents' rights as of October 2nd. So we will review those updates as well. So let's get started. When we're talking about residents' rights for nursing home or long-term care residents, they are primarily located in Revised Code 372113. There are now 36 listed, and they sort of break into 3 categories: personal rights, financial rights, and discharge rights. So your personal rights are things like you have the right to live in a safe and clean living environment. You have the right to be free from abuse, be treated with respect. You have the right to adequate and appropriate care. You have the right to participate in your decisions and have your records kept confidential. You have the right to privacy during your exams or treatment. You have the right to exercise all civil rights. Always that discussion about voting rights, that is included. You have the right to private and unrestricted communications, right to choose your own pharmacist. You have the right to consume reasonable amounts of alcohol and tobacco unless there's a written policy of the facility prohibiting this, or written doctor's orders that also prohibit it. You have the right to get up and go to bed when you want, but you cannot be disturbing others with regard to the same as to meals. But if there's a posted meal schedule, then they can require you to follow the posted meal schedule. You have the right to participate in religious, cultural, social activities. You have the right to voice grievances. So, good example of that type of case, one of our cases we had that was in litigation. The client was complaining about the care that she was receiving to her daughter in the coffee shop. And the administrator came over and said, that's not appropriate for a discussion here in the public coffee shop. If you want to complain, then you need to come do this privately with me, something along those effects. Well, Clearly, no. You have the right to voice those grievances. You have the report to the right to have health changes reported to your sponsor within 12 hours. So those are the flavor of personal rights. The next category we talk about is financial rights. So financial rights include a disclosure of the basic rate and any additional charges. Sort of like for our lawyers, the landlord tenant notices, you have to have a 30-day notice before the rates are increased or changed. You have the right to receive an itemized bill listing all charges and all payments. You have the right to be free from financial exploitation. The facility can't misuse the funds that are in your trust account. And yes, we have seen that. One of the facilities down here, he was infamous for picking up homeless people that might have Social Security funds held in by Social Security because they were homeless. And so then he would apply, become the repayee, and get lump sum back Social Security benefits, which he would deposit in his business account. Obviously, a violation of financial exploitation rights. When there is a trust account, you have a right to a quarterly accounting statements, which includes all funds, all property deposited with the nursing home, a list of all deposits and withdrawals supported by receipts, and unrestricted access to your property at reasonable hours. So this is, again, talking about the facility basically maintaining a resident trust account. So this property that the facility is holding, they are essentially a fiduciary or a trustee. We recently had the situation where two facilities here in Ohio filed bankruptcy, and on their bankruptcy statements, they listed the trust accounts, but did not exempt them as being owned by the residents. And then in the sale, basically, they were going to waive the residents' rights. Probably not intended, but that's what the court document said. And we essentially advocated to get a corrective decision by the judge that upon the sale, these tenant accounts and tenant properties, resident accounts and resident properties remain their property and not the property of the facility. Okay. Is there any questions with regard to those two sections? Otherwise, we'll move on to the discharge piece, which we will spend most of our time on, as this is the number one complaint that we still hear and see is the improper discharge.
I do not see any questions in the chat yet.
Cool. All right. So we will, like I said, talk about the rights regarding discharge. And the number one issue here is that they have the right not to be transferred or discharged. So that's where we start. You have the right not to be discharged, except, okay? You can be discharged if the facility can no longer meet the resident's needs. The resident doesn't need the level of care, which is an intermediate level care. The resident's health or safety, or the resident is placing the health or safety of others at risk, or probably the one we see the most, failed to pay for care. But this also means both a Medicaid application denied, and if appealed, denial upheld. Since you have 90 days within which to appeal a Medicaid application denial, you can see this essentially will give you quite a bit of time by filing a Medicaid application. And then, delaying the appeal as long as necessary. Okay. But these are the reasons that the facility can try to discharge you. These are also limited by many other things, which we will talk about. But I will indicate first is when we're talking wrongful discharge, what are the kinds of things that we hear frequently? The facility calls the family member, son, daughter, and these can be very educated members who hear the facility say, your rehab days are done, are complete. So we're discharging mom or dad today or tomorrow. Okay. Your rehab is complete. So we're discharging you tomorrow. Your Medicare days have been excluded. So come get them. We're discharging them tomorrow. And family members who don't know better say, oh, okay, that must be the way it is. I'm going to come and get mom or dad and do the best I can, even if they're not ready to come home. They don't know that they could say no to that discharge. But like I said, because the facilities, say, hey, your days are complete. Right? We hear it all the time. The rights, however, are that you have the right not to be transferred. Okay. And there are criteria as to that process, which we will talk about in a minute. So who can enforce your rights? A sponsor may enforce those rights. A sponsor is defined as an adult relative, friend, or guardian who has an interest or responsibility in the resident's welfare. So break it down. This can be an adult relative or a friend who has an interest in the resident's welfare. That does not require a legal document for them to exercise. If the resident says, I want my friend to be my sponsor, what that means is the sponsor then has the right to speak for the resident and enforce their rights. Any attempt to waive those rights is void. But we will see this word sponsor, however, in written contracts, which we'll talk about 3 weeks from now, or in enforcement by the facility for discharge is often misused. This is the sponsor who can enforce your rights on your behalf. It is not an obligation that the sponsor takes for care of the resident. Okay, so what is the discharge process? It must be in writing. It has to be served on the resident and by certified mail on the sponsor. The notice has to be sent to the State Department of Health, and it has to be served at least 30 days prior to the proposed transfer or discharge date. So it has to be 30 days. What are the exceptions to the 30-day notice? Health improvement to allow transfer to a less skilled level of care. So you're moving them from assisted living down to independent living, for instance. The resident has resided in the home less than 30 days. An emergency, because the safety or health of other residents are endangered. Medical needs of the resident require immediate transfer. But note the caveat, and that is you still must provide notice as many days in advance as practicable. So in the discussion we had, your Medicare days have run out. Typically, those are 20 days. And the nursing facility will say something like, oh, he's only here for rehab. He's not a resident. He hasn't been here for more than 30 days. So therefore, we don't have to give him a discharge notice. Note here that oh, even if the resident has resided in the home less than 30 days, he's still entitled to a notice for a reasonable period of time prior to the discharge. So the answer when they're saying Medicare days are complete, come get them, is to say, no, we disagree. They still need additional care. All right. So let's look at our fact pattern that we'll build out as we go through today. Mrs. Jones suffered a heart attack and she fell, breaking her hip. Mrs. Jones enters ABC nursing facility for rehab under Medicare. ABC is a corporation, for-profit corporation that owns a chain of Ohio nursing homes. She is married. Her husband, Mr. Jones, is 80 years old and uses a walker. Their home is a 2-story home. Mrs. Jones' 20 Medicare days have expired and the facility calls Mr. Jones to come and get her as she's being discharged tomorrow. She cannot walk the stairs and still needs assistance with dressing and bathing. And when questioned by Mr. Jones about the appropriateness of sending her back to him where he cannot care for her, the facility says, oh, we don't have to give you a notice because she was not a resident for 30 days. So here is our first poll question. Facility can discharge Mrs. Jones to her home without any notice because she's not been there for 30 days. True or false?
Okay, that was a fast one. I'm going to go ahead and close it. Got quick responses.
All right, vast majority of you say false. That is correct. They must give notice. If Mr. Jones does not agree, they must give notice. Okay. It doesn't have to be a 30-day notice, but it must be a notice for a reasonable period of time. They cannot just say, oh, sorry, you must get him now. As we will see when we talk about the discharge notice content, is that if you accept Mrs. Jones in that situation, then you have agreed. Okay, and then they don't have to give a notice because you've agreed to the discharge. So let's go through what must be in the notice itself. As we said, it must be in writing. It has to include the reasons for the proposed discharge, the proposed date, the proposed location, and a notice that the resident sponsor may choose another location. The notice has to advise the resident of their right to an impartial hearing at the home on the proposed transfer discharge and how they can request a hearing. There has to be a statement that the resident will not be transferred or discharged before the date specified in the notice, unless the home and the resident agree to an earlier date. The address of the Legal Services Office for ODH, and the name and address, telephone number of the state long-term care ombudsman.
Is there a question, Miriam, about how do you determine a reasonable amount of time for that notice if it's not 30 days?
Yeah, so there is nothing to tell us what reasonable amount of time is, but basically what the statute says, it has to be practicable. And, the answer would be, it's got to be sufficient amount of time to give everybody the notice so that they can request a hearing. Okay. And as we will talk about, when you get a notice, you still have 10 days to request a state hearing. But practically speaking, the answer is going to be say no, contact our ombudsman to advocate, and there should be a meeting set up to discuss that discharge process. You know, what you don't want is to have them discharged to an improper location by consent. So, yeah, there is nothing to tell us what that reasonable notice number would be. So, okay. So let's also talk about what is also prohibited even when you're going to discharge. And that is going to be that the proposed location must meet the resident's health care and safety needs. So is discharging Mrs. Jones to a 2-story home with no services in place for Mr. Jones to care for going to meet her needs? Or is she going to be at risk? And clearly from our facts, she would be at risk. No home can transfer the discharge to the resident before the date in the notice, unless the home and the resident agree to an earlier date. Then the resident or resident sponsor may challenge the transfer by requesting an impartial hearing within 30 days. However, you must request it within 10 days to prevent discharge while appeal is pending. So it would seem in order to have your 10 days, that a reasonable time would mean that you have to at least have 10 days. And the resident can appeal the state hearing decision to Common Pleas Court, which would be another 30 days, but practically speaking, you're going to have to act quickly to prevent the discharge so that they could stay at the facility while the appeal is pending. Now, what happens if they've already been discharged? We will talk about that in a few minutes, but essentially they will have the right to be returned to the facility. So want to talk a little bit about the major changes that occurred October 2nd of 2023. Prior to that, the state hearing officer's authority only referenced A30 or 372113 A30, which was the grounds that we listed before. And so therefore the evidence and the only issue before the state hearing officer is whether the facility has met the grounds. And even though the facility is required to provide the discharge plan, et cetera, in the notice, the hearing officers basically said, well, we can remind them of their obligation, but we can't really address it at this hearing. That has changed. I would, highlight as well under their authority statute, which is 16E, it says that the resident is discharged, and the hearing officers would put that in the reminder of their decision. Although we've approved the discharge, facilities reminded under E, they still have to do a proper discharge plan, including that the facility or the place to which they're being discharged has accepted them. That was changed with House Bill 33, which went into effect October 2nd. We added 1331, which means you also have the resident has the right not to be transferred or discharged from the home to a location that is incapable of meeting the resident's health care and safety needs. We added 32, which is the right not to be transferred without adequate preparation, which includes medication, equipment, healthcare services, and other necessary services. And as we'll talk about under the federal criteria, this basically fits in with there should be adequate preparation so that the transition to the new living environment will be successful and the resident will not be at risk. Previously, it was not unusual, as we've indicated, that the facility would try to send the resident home and not even provide medication or durable medical equipment or any kind of services. The resident was left to scramble around to try to get that set up after they were already home. In addition, we've incorporated the federal regulations with regard to transfer or discharge rights, which we will review under 483.15 and 21. In addition, as I indicated, what E used to say, you could see has been changed. So now it is if a resident is to be transferred, the home proposing the transfer shall provide the resident with adequate preparation, and the home or alternative setting to which the resident is to be transferred shall have accepted the resident for transfer or discharge. So in the past, it was not required that the new facility has accepted them as of the date of the hearing. So the fact that the new facility that's proposed in the notice, or some other facility that they choose later on, hadn't accepted them or didn't even know about them, which frequently occurred, the state hearing officers would say, oh, well, they're reminded that they have to choose a place that has accepted them. Now this is clearly to a process of the discharge plan itself prior to the actual discharge, and is now under the jurisdiction of the state hearing officer to address at that hearing. Now, unfortunately, the regulation, which is in 3701-6103 and predates the change in the statute, provides that the proposed location need not have accepted the resident at the time the notice is issued. So how do we reconcile those? Clearly, however, the facility that the proposed location that has to accept them has to have done so by the time of the hearing, in order to establish that the hearing, that the facility has met the proper discharge planning that is required, that the hearing officers can now address. Also amended was 3721-161 to include, as I said, in the statute, that the hearing decision, the hearing officer is to address whether or not the transfer or discharge complies with A30, which is the grounds through A33, and 3721-16. The home has to do this as part of the discharge plan. If the homeowner has transferred or discharged the resident before that hearing decision, then the home shall readmit the resident in the first available bed. So our example, the case we had, was they literally Ubered our client to a homeless shelter. As a result of that situation, the resident ended up back in the hospital, who discharged him to a hotel. And then he called us about, how do I get my stuff that was still at the facility? We requested, our ombudsman requested a state hearing, and the facility tried to argue he consented to being Ubered to the homeless shelter, which the hearing officer did not buy, and the facility had to readmit him to the nursing home. Obviously, we worked hard to avoid that because of the trauma suffered by the resident in being discharged to an unsafe location. So, upon receiving the request, the hearing officer is to determine whether the proposed transfer complies with A30 through A33 and 3721-16. So, reminder, A30 provides the right not to be discharged unless you cannot meet the resident's needs. The resident no longer needs that level of care. The health or safety of others is at risk, or you have failed to pay for care, which means both Medicaid application denied and if appealed, denial upheld. But 31 through 32 and 33 is again that the transfer to the location that must be capable of meeting the resident's needs. And there must be adequate preparation, including a proper services. So if those are not in place at the time of the hearing officer can and has deny the facility's right to discharge. So what is this hearing process? Again, the notice of the date, time, and place of the hearing shall be sent to the administrator, the resident, and any sponsor. The notice will also inform the administrator, resident, and sponsor that they have a right to appear at the hearing in person, have their attorneys or representatives, but no scheduled hearing will be postponed except agreement of both parties. Now, still under the regulation, again, predating the statute, discusses the evidence to be presented and indicates the administrator shall present evidence on testimony or written materials that show by a preponderance of evidence that the proposed transfer or discharge complies with Division A30. It does not discuss A31, 32, 33. And then the resident has a right to produce evidence as well as to why it does not comply with A30. However, statute still requires the hearing officer to consider A30 through A33. And therefore, I believe you're still going to be able to present evidence on both sides of that issue because the officer has to collect evidence in order to make its determination that the facility has complied with A30 through A33. Unless the parties otherwise agree, hearing officer shall decide within 5 days. After that, you can file an appeal in the common pleas court for the county in which the home is located. You can request the filing fees be waived due to indigency. It must be filed with the department and the court within 30 days after the hearing officer's decision is served. You have to serve opposing party hand delivery or certified mail return receipt requested. Now, practically speaking, you need to file that quickly before the actual discharge date because you want to also ask the court for a motion for stay on the discharge pending the appeal. We have not had any trouble with courts granting that motion, but you need to file that with your notice in order to get a temporary order to prevent the discharge. Otherwise, you're in that situation we discussed before, which means, oh, you've already been discharged. And so now if you win, which could be several months later, you can go back, which does not solve our problem for our residents who need that care. Generally speaking, the transcript is not provided absent a court order, but only if the parties are unable to stipulate to the facts and that the transcript is essential to determination of the appeal. If the court orders it, the department would file the transcript within 30 days. Generally speaking, they will file a recording of the hearing and not do a transcript unless the court orders it. There is no bond required for this type of appeal. So let's look at our facts again that we talked about. Mrs. Jones, who had suffered the heart attack and fell and broke her hip, and the facility took her in for rehab. The facility is trying to discharge her to Mr. Jones in an improper, unsafe kind of discharge. Her 20 days of Medicare days expired. The facility tried to get Mr. Jones to agree to accept her. So Mr. Jones successfully challenged the facility's attempt to send her home. The facility now issues a 30-day notice to discharge her to Mr. Jones' home. Although the notice contains all the required information and is properly served, the location they have identified in the notice is Mrs. Jones' home address. Again, this is frequently what we have seen in these notices. What should Mr. Jones do? Poll question number 2. Should Mr. Jones call his local ombudsman, do not accept Mrs. Jones, request a hearing, or all of the above?
Almost everyone. We'll give you a few seconds.
I'm giving you easy poll questions this time.
No math in them, right?
Exactly. And when I give the math, then even I do it wrong. So there you go. And I'm the math major, man. So
okay. There, can you see share results?
There we are. Okay. All of the above. That is the vast majority, and that is correct. All right. So you want to call your local ombudsman. Okay. That's number 1. They are the resident patient advocates, and they should assist you on the rest of these steps. Number 2, do not accept Mrs. Jones. So the facility says, we're going to put her in an ambulance and send her to your house. Okay. If you accept her, they will say you consented, and therefore there's no reason for a hearing. Again, you can request a hearing, but you want to eliminate that risk to her. Request a hearing, absolutely. That is the next step. And so all of these are the ones that should be chosen. All right. As we noted on these appeals to common pleas court, either party, the facility or the resident, can request it. So can the facility seek a court order to evict the resident? As we noted, it says that the home may commence a civil action to enforce the decision of the department or the court. The court finds that the resident home has not complied with the decision, it shall enjoin the violation and order other appropriate relief. So can this be read to say facility can literally evict them by putting them out on the street or send them home or to some other improper location? The reason I raise this is because there are facilities, attorneys who are attempting this. So here is a recent complaint up in Cleveland, and the language right out of this complaint that they issued a notice of discharge for non-payment. The facility, no hearing was requested. So the facility says they may transfer on the date specified in the notice of discharge. Apparently the notice said we're going to discharge the resident to the resident's son's home. So therefore, since the resident did request a hearing to challenge the notice, the resident is, quote, not entitled to remain at the community and is not entitled to receive services. Hopefully some of my ombudsmen are on here or are pulling their hair out. Should be. The resident has wrongfully remained at the facility, and the resident's son has wrongfully failed to remove the resident from the facility, despite his awareness of the discharge plan for the resident and his duty to comply with the notice as resident's representative. So we have reviewed those regulations and the statute as a resident's rights. It read to me as if the sponsor may enforce the rights, but it did not put obligations on the sponsor to come get the resident. But in this complaint, they put in that the facility is entitled to a restraining order, an injunction, enjoining the resident from remaining at the facility and mandating that the resident's son remove the resident from the community. So, you know, what we've already discussed, doesn't the facility have the obligation, even in the discharge, to do a proper discharge plan to a place that is capable of meeting the residents' needs? And we'll explore that further. Do any of those go away if the notice of discharge was not appealed? Facility still has this obligation. And there was no hearing, so how are they enforcing a decision that was never issued? Clearly, however, the facility still has this obligation to do a proper discharge plan, and there's no obligation on the family member who's acting as sponsor to remove the resident. Discharge is all based on what the facility is obligated to do and prove by preponderance of the evidence. Still in that complaint, the relief they requested, judgment in favor of the facility and against the defendants, awarding facility a temporary restraining order, a preliminary injunction, and a permanent injunction, enjoining the resident from remaining at the facility and mandating that the son remove the resident from the community, plus an award of attorney's fees. So, having gone through that, this clearly does not meet the law and the requirement for proper discharge plan, what is the remedy against the attorneys for filing this? And this would be what we call the Fair Debt Collection Practices Act, which we will go into more detail in 3 weeks. But this prohibits debt collection attorneys from using deceptive means in order to collect debt. This is clearly done to intimidate the resident and the son to removing the resident, even if that removal would put her at risk. Now let's talk briefly about, so one of the things we want to talk about on that last slide of, so legal aid attorneys and stuff, what should we do, or what happens if we do nothing, since it's so outrageous? I will tell you, we have seen these cases before the amendment. No one filed anything, so default judgment was rendered, and the debt collection attorney then sought a citation to hold them in contempt with an order of arrest. I know, absolutely outrageous, but that is what happens if nothing, if these cases are not defended when these attorneys try this. Have we seen this in Southwest Ohio? Yes, we have. Have we seen actions similar to this with regard to these debt collection attorneys in the past? The answer is yes. Have we seen these debt collection attorneys, or this law firm specifically, file these in Southwest Ohio since then? The answer is no. Clearly, they are filing them in Northern Ohio. So one of the things we want to talk about with regard to our trainings is, defending our vulnerable seniors and residents statewide in order to prevent debt collection attorneys of the facility from trying this kind of thing. Anyway, so much for my soapbox. Yes.
There's a question about discharge. If a resident is discharged to their own home, how would the resident not accept the transfer if there were no other family members involved?
Yeah, so let's say they literally forcibly put you in there and put you on the street on your home. This is sort of what happened with our client when they took him to a homeless shelter, right? Clearly the answer is going to be they need to be in touch with the ombudsman before that happened, hopefully when they got their notice. If it happens while they're there, like Medicare days are complete, again, they need to contact their ombudsman immediately, so that a state hearing can be requested and they can get back into the facility. As we will talk about as to violations in that situation, that could be compensatory damages, that could be injunction, that could be attorney's fees, in later on for the legal remedies. But for the immediate remedy, immediate relief is going to be contacting their ombudsman. So still part of our discharge, okay, is going to be the federal resident rights provisions that are in 483.15 and 21. So let's review some of those requirements, and they are substantial under the federal law. Number one, there must be documentation. The facility must ensure that the discharge is documented in the medical record and appropriate information is communicated to the receiving healthcare institution or provider. If this has occurred where they just send them to a new facility who takes them in and they have absolutely nothing. This is a violation of 483.15, which is now incorporated into our state laws. What's in this documentation? The basis for the transfer. If they say, oh, it's because we can't meet their needs, they must identify the specific need that cannot be met, how the facility attempted to meet that need, and how the service is available at the receiving facility to meet that need. Back to our question in the chat about sending them home. Obviously, that's not going to meet that. In addition, the documentation must be a physician. It would be the resident's physician if it's because of the resident's health, or any physician when the transfer is for a reason for any other reason, basically safety, failure to pay, cease operations. Okay, so there must be a doctor's note included in that documentation. Information provided to the receiving provider must include a minimum of the following: contact information of the doctor, the sponsor information, advance directive information, all instructions for ongoing care, a comprehensive care plan goal, and any necessary information, including a discharge summary, to ensure what? A safe and effective transition of care. So the goal is this is supposed to be a seamless transition, not a get rid of this problem, which tends to be the facility's approach. In addition, we had probably the number two or frequent way they try to deal with this is, oh, discharge them, quote, to the hospital and not accept them back. Right? This federal regulation requires a written policy on permitting residents to return the facility after they are hospitalized. And the policy has to provide a resident whose hospitalization exceeds the bed hold day and wants to return to the facility means they must be allowed to come to their previous room or upon the first available bed in a semi-private room. As long as the resident still requires nursing home level of care and is eligible for Medicare skilled facilities or Medicaid nursing facility services. This latter is so that we can connect it to federal law, because those are federal programs providing services. So there is the right to return to the facility, and there needs to be a written policy regarding allowing this, except in certain criteria. And this is probably something the facilities who are notorious for this do not have yet. If the facility is going to say, well, they still can't return, guess what? They have to comply with the discharge requirements that we've already talked about. It can only be for the specified reasons. They have to document, and the resident has a hearing right. And returning to the facility means returning to the same area. In one of our cases where there was a Medicaid problem, failure to pay, the facility moved her from her room that she'd been in for over a year on the first floor to the second floor, which was a locked unit where many of the memory care or the residents with dementia or Alzheimer's were residing. Of course, she did not have that issue. And no reason was given. Oh, well, now you're long-term, so we're moving you from one part to the other. So this federal regulation tries to address some of that. And that is that long-term care means long-term. You're trying to keep the resident in the most familiar and comfortable situation, living situation. That this is a home kind of situation, and this is not appropriate for the residents to be, just shifted from one location to another for the convenience or other reason for the facility. The federal regulation also discusses what we call person-centered care, meaning there needs to be a comprehensive care plan for each resident that includes objectives, timeframes to meet the resident's medical, nursing, mental, and psychosocial needs, and must describe the services that they are to receive to attain or maintain the resident's highest practicable physical, mental, and psychosocial well-being, and any specialized services that they may require. And they, again, document everything, why the services are being continued or discontinued. Think in our case, oh, we're discontinuing the therapy because you have no source to pay the therapy any longer because Medicare's run out. Well, the purpose of the therapy is to maintain the resident's highest practical physical, mental, and psychosocial well-being. Well, if they need physical therapy to maintain their physical condition, then under this regulation, they're required to do so. They are to determine this plan with the resident and the sponsor, including their goals and their desired outcomes. Also, with regard to discharge planning, the facility must develop the planning process that focuses on the resident's discharge goals, the preparation of the resident to be an active partner, and effectively transition them so that we reduce the factors leading to preventable readmissions. They have to follow what we discussed in 15 and ensure the discharge needs of the resident are identified, and consider the caregiver support person availability and the resident or caregiver support person's capacity and capability to perform the care as part of the discharge needs. They are to involve the resident and the sponsor in the discharge plan and inform the resident and the sponsor of the final plan. So this is to be a mutual kind of discussion, which frequently does not occur. But again, back to our facts where, you haven't paid, so we don't have to provide services. Clearly, even in that discharge situation, they have to consider the support person's availability and capacity to perform the required care. The resident's son, there is no indication that he is capable of providing for the resident's care. There's to be a discharge summary, which recapitulates the resident's stay, includes all the course of care, reconciliation of all medications, and the plan that is developed with the participation of the resident, which will assist the resident to adjust to his or her new living environment. These are all, again, incorporated into Ohio's discharge plan now through the changes in the statute. Now, before we move on to additional federal rights, which were not incorporated, but are still relevant. Questions, comments with regard to the discharge plan itself?
Yes, we have a couple questions for you.
Mm-hmm.
Joy asks, are these notice rates and remedies applicable in assisted living facilities where the individual is private pay?
Yes. That's a quick answer. In answer to the question, yes. The discharge rights apply to both what we call residential care facilities or assisted living facilities, as well as nursing homes. And the pay issue is not relevant unless you've applied for Medicaid. Now, you do run into the problem with assisted living, obviously, that it's the facilities do not have to accept Medicaid for the bed in which the resident may be residing. This is a specific waiver program. It has been an issue that we have looked at. For instance, assisted living facilities are also notorious for this policy that you must be private pay for X number of years, 6 months, 1 year, 2 years. It changes depending on the day. After which time you've private pay that long, then we will give you a waiver bed if available. Our answer to that has been you still have to do a discharge and a proper discharge. And if you have applied for and your Medicaid pending under the assisted living waiver, okay, and if there are beds available, then you could certainly contest that. Most family members don't want to risk the discharge, however. So it has not become a case that we can pursue because you would need both that. The money is gone, they've applied for Medicaid or approved for the waiver, and there are waiver beds available. So, but in essence, yes, the residents' rights provisions apply to assisted living facilities. Sorry about that. Long answer. Go ahead.
That's okay.
Next question.
The next question, well, there was a comment and a follow-up question to it. Trina said, I wish there was a requirement that the nursing home must alert an ombudsman about any discharge so people understand their rights. And then Mary followed up and said, this is a good question because the notice does go to the state ombudsman's office, correct?
Correct. So yes, there is a notice. They have to send it to the state ombudsman. And so the state ombudsman, my understanding, at least which happened here, is those discharge notices are then sent to the regional ombudsman office to address that. So the regional ombudsmen do receive those notices. Now, different story, obviously, with regard to they don't have a notice at all. Oh, your Medicare days are complete. And unfortunately, the answer there is getting the word out, say, go talk to our helpline, okay, who can direct you to those sources. Or if they reach out to our legal aid partners, et cetera, call the ombudsman. So go ahead. Next question. Or is that it?
I think that's it for now.
Cool. All right. We want to talk a few minutes about additional rights which are in the federal regulation. Okay, so they are binding on facilities that are Medicaid and Medicare certified. Enforcement, however, is a different problem. But let's talk a little bit about those. Visits with family. Facility must provide immediate access to a resident by an immediate family or other relatives, subject to their right to deny or withdraw consent at any time. Facility must provide immediate access to a resident by others, subject to reasonable clinical and safety restrictions and the resident's rights to deny or withdraw consent at any time. We highlight those because we do run into those questions with regard to a guardian or someone under healthcare power of attorney is restricting access for friends, family members, even attorneys to talk to the resident, because the guardian has said, well, no one could talk to him. In this case, we are talking about the resident who has that right and their right to deny or withdraw consent. Okay. I would look at saying, is there reasonable clinical and safety restrictions? Is there a reason for this that, a doctor or someone has documented that visiting with this family member is detrimental to the resident's health or well-being or safety? This is certainly an exception, but I would say you have to document that. And even when they are declared incompetent, simply because the court has determined that they are not competent doesn't mean that they cannot consent to seeing their family member. Obviously, if it becomes a dispute, so the facility wants to stay out of it, then the family member would be directed to talk to complain to the probate court where there's a guardian. But essentially, the resident still has the ability to say, I want to see a family member, unless, it is going to be a physical or a mental or safety issue. Family councils. This was a recognized desire of our former head ombudsman who passed away, Bob Vimes. He was a huge proponent of family councils. So the resident has the right to organize and participate in groups in the facility. The facility must provide the resident or family group with a space and take steps to make everyone know about the meetings. Individuals can attend only by consent of the group. The facility must provide one staff person who is approved by the family group and approved by the facility, who's responsible for providing assistance and responding to written requests that the group puts forth to the facility. The facility is required to consider the views of the resident or the family group to act promptly upon those grievances and recommendations. In that consideration, they must demonstrate their response and their rationale for such a response. And it does not mean the facility must implement every request of the family group. But good question is, we all want private rooms. Facility can say, thank you for your suggestion, but we can't afford to do that. Okay, and there's no requirement. Sorry, semi-room is semi-private is the best we could do. Would be an example. But they need to consider and act upon them. Again, the idea being we want the residents and the facility to work together for the benefit of all. The residents have right to participate in family groups that are set up, and they can have family members or other sponsors meet the facility with the families or sponsors of other residents in the facility. They have those rights. Okay, so those are additional rules that still govern our facilities and are worth, considering for the future benefit of our residents. So what happens if these rights are violated? What can you do? The first step, we already talked about it, is contact the ombudsman for the facility. These individuals are licensed social workers who act as the resident's advocate to work out complaints between the resident and the facility. There is the website for you to click to find your local ombudsman. There's also a My Care Ohio ombudsman through the regional office. And this is our number here for our ombudsman program for Southwest Ohio here at Pro Seniors. But the purpose of the ombudsman is going to be to advocate for these resident rights for the vast majority of them. Okay. Certainly in our area, the ombudsman frequently handle the discharge hearings. So having a partnership with the legal aid department or legal aid office, as we here at Pro Seniors do, is extremely beneficial because our ombudsman can come and talk to us, to the legal side, in order to get advice and some of these great citations, et cetera, as to advocate at these hearings, these discharge hearings. And of course, if it becomes appropriate, the legal aid department can then, as we have done, take those appeals to common pleas when necessary. A lot of these rights that we talk about, like family councils or to right to appropriate care, et cetera, are best resolved with the ombudsman's office. And that's what they do, and they do a great job. So
Miriam,
yes.
there was a follow-up question about ombudsman
Yes.
regarding that notice that you talked about a little bit ago, and they had questions about if the ombudsman receives that notice, do they reach out to the resident?
I believe they try to, or they should. Okay. I don't know if I have any of my local ombudsman on here. But yes, they should try to reach out to that when they can. I will say, our ombudsman cover something like 300 facilities in our 5 counties. So I'm sure that all of the regional ombudsman offices are similarly overloaded. But I believe that is their goal, is to always reach out whenever those notices occur. Okay. Any other questions?
Nope.
All right. What other remedies do we have? Complaint to the Department of Health. What will the Department of Health can they do? They will investigate. They can cite. They can issue compliance orders. They can issue daily fines. And these fines are per day and per resident, but you only are required to pay those if you don't correct the error within a reasonable time, the non-compliance. And unfortunately, one of the amendments that went through under 3721-162 was with these complaints, the Department of Health shall investigate any complaints. However, all the time frames, i.e. that they had to do this within so much periods of time, like 30 days, or deal with within 7 days when it's in unsafe conditions, etc. All of those were removed just to the time frame. So they're still required to investigate, but doing it within 7 and 30 days does not exist in the statute any longer. Regardless, how you reach the Ohio Department of Health, as to nursing home complaints, there is a phone number, there is a website. Provide as detailed information as possible, including the name, address of the facility, date, time of the incident, and identifiable resident, patient, staff information, etc. And I would recommend at this time, even though you think, oh, well, I've done it and they won't do anything or whatever, more is better. If we have 20 residents or 30 residents complaining about the same thing at the same facility, is going to be more effective and get their attention as opposed to one. The more detailed, the more serious the complaint, obviously, will get their attention as well. But yes, more is better, and it is a matter of keep putting it in the record, making the record to get their attention. For our attorneys out there, what other remedies are there? Okay, there is the provision for civil action, which includes compensatory damages. If negligent, can include punitive damages when appropriate, but also includes injunctive relief. And if you're just seeking an injunctive relief to, say, prohibit an improper discharge, or to prohibit an ongoing violation of a resident's rights situation, you can also seek attorney's fees. And essentially, we are talking, there is a private right of action to enforce residents' rights violations. And with the new statute, the federal regulations, which we've discussed, which cover discharge planning, etc., are also incorporated into the Ohio statute and therefore are also enforceable as private rights of action under the Ohio law. So I sort of, so let me, before I go on to that, we sort of talked about it before as to our example of we're just going to discharge you to the resident's son's home, and the resident's son must come get them and get a court order to come get the resident because they're not entitled to be here and not entitled to services. Why is it important to defend this under that civil action statute? Because they will get a default judgment if no one files an answer. And unfortunately, our common pleas judges know even less about the residents' rights statute. And they will frequently, I assume that the attorneys know what they're talking about, will sign off on default judgments, which can include orders like this. And if no one takes action after that, because you're like, well, they can't discharge anyway, they will come back and seek a citation from the court to find the resident in contempt for failure to comply with the court's order. and ask for, as part of that citation process, ask for a body attachment, which means basically an arrest. Okay. We have seen it down here in Southwest Ohio. Fortunately, the judge in that case sort of sent, because they had seen in the record the ombudsman had been involved, had sent a copy of that to our legal department, at which point we were able to defend that case. But it is something that they have tried and will continue to do so unless someone stops and files an answer and says, wait a minute, you're not authorized to do this. So now under the Federal Nursing Home Reform Act. So 42 USC 1396R sets out the requirements relating to residents' rights. And my question is, are these enforceable as civil rights violations under 1983? So the U.S. Supreme Court recently determined specifically that pre-discharge notice and unnecessary restraint provisions of FINRA are enforceable under 1983. That would seem to fit into what we've been talking about. However, there are limits to 1983, and that is that a 1983 action is limited to actions by the state. In other words, the state shall not violate an individual's civil rights provided by federal law. That does not extend to the federal government having authority to regulate private individuals. Okay, so the nursing home then must be a state actor. So in the Supreme Court case, the nursing home was a county home. And case law here in Southern District, Ohio, is that simply receiving financial support through Medicaid, and even though you're regulated by the federal government, that does not make you a state actor, and therefore you do not necessarily have a private right of action for violation of 1983 civil rights. So these federal rights don't become civil rights unless it is a state actor who is violating them. Unfortunately, that's not going to be enforceable. So what's the remedy? Obviously, they are regulated. If it's not incorporated into Ohio law, as we have already indicated, then the remedy may be complaining to CMS to enforce federal obligations that the facility is not following. But that does not give you necessarily the right to sue for violation of civil rights under 1983 against a private nursing home. So back to our example of Mrs. Jones. She is at the ABC facility after having broken her hip and suffered a heart attack. Her Medicare days expired. And they tried to get Mr. Jones to come and get Mrs. Jones, even though she could not walk the stairs and still needs assistance with dressing and bathing, and he's 80 years old on a walker. First, they tried to say, well, no notice is required because she's only here 20 days. So they did what we've been talking about. They, day 21, put her in an ambulance and transported her home. And Mr. Jones, he could not leave her in the driveway, so he brought her into the home. But he contacted the ombudsman, who requested a state hearing, and successfully advocated for her return to the facility. But due to the stress of being wrongfully discharged, she suffered a stroke. Mr. Jones, wanting to prevent this from occurring ever again, against other residents wants to sue the facility for violation of her rights under the Federal Nursing Home Reform Act. Poll question number 3. Will Mr. Jones be successful in bringing 1983 action for civil rights violations again, suffered by Mrs. Jones, I should say, against the facility? Sorry. Yes, because they wrongfully discharged her. Her rights under the Federal Nursing Home Reform Act were violated. No, because she has no private right of action to enforce her rights, or no, because nursing home is a private facility and therefore not a state actor.
Okay, we'll give everyone a few more seconds to answer the poll. This one's a little trickier. Okay, there you go.
Okay. All right, so we got a mix. Yeah, so technically, the answer would be the nursing home is a private facility, and therefore you cannot sue her under the under FINRA for 1983 action. Okay. The third one was a little trickier because it says she has no private right of action. Well, she has a private right of action, but not necessarily against this facility under 1983. Yes, she was wrongfully discharged, and her rights may have been violated under the federal statute, but the nursing home is a private facility, and therefore there is no standing, unfortunately, to sue under 1983 for a civil rights violation. So, but what does that mean? Do we have any remedies? Yes, you still could sue, okay, for compensatory damages, even punitive damages under Ohio statutes, okay, 372117 for violation of her rights under that provision. Okay, you could certainly sue them for negligence, etc., under state law. But unfortunately, unless it is a nursing home run by the state, we cannot use 1983 as a remedy for our nursing home residents.
Miriam,
Yes.
there's a question from Robert about malpractice. It said, will ODH respond to a medical malpractice complaint regarding a nursing home therapy procedure that physically injured the resident, or is the resident recommended to get an attorney to state their case?
So what the Department of Health should do is they should investigate it, and they should perhaps cite them for the violation. But the remedy as to damages is going to be a private attorney who's going to have to establish that they violated reasonable care. Okay, so seeking remedy from the Department of Health is really going to be to fix the problem for other residents.
And Robert had another question about
Yes.
polling question scenario. He said, isn't the poll question a tort case?
Yes, absolutely. You could bring a tort for that scenario, right? But Mr. Jones wanted to seek a remedy for civil rights violations in federal court, basically, which would be a different remedy, which is not available to him. Doesn't mean he couldn't sue for negligence, or as you said, as we indicated, you could also seek remedies through the statute, the Ohio statute. Okay, so we got about 5 minutes. I wanted to just highlight an issue we have seen with regard to home closures. We've had that where they voluntarily frequently said something like, oh, we're renovating the rooms. So you're being discharged in 30 days because we're renovating your, a certain set of rooms. So is 30 days sufficient? Is what the question has come. Or is this really a home closure? Now, it would seem you're thinking, well, they're not closing the whole facility, they're only closing some rooms. Okay. But again, remember, what's our grounds for the discharge? The grounds for discharge have to be that the home is being closed or otherwise ceases to operate, or the resident is recipient of Medicaid and the home's participation is involuntarily terminated. So, in our scenario where, oh, we're going to renovate 5 rooms, so you have to be discharged, okay, that is not one of the grounds. You have the right not to be discharged, okay, unless the home is being closed. So, what is closure defined as? The discontinuance of the use of the building or part of the building that houses the facility as a nursing facility, and that results in the relocation of the residents who continue to require nursing facility services. During a closure or a voluntary withdrawal from Medicaid, there must be a notice to the Department of Medicaid, the resident, and the sponsor, a written notice at least 90 days prior to the closure or the voluntary withdrawal. And if the nursing home does not issue the proper notice, there are penalties to which they could be subject. So when we talk about Department of Medicaid, what a provider agreement means, the agreement between the Department of Medicaid and the nursing facility. No home can terminate the provider agreement similarly with at least 90 days prior to such termination. So we've had the question, oh, you all have to leave within 30 days because we're no longer going to accept Medicaid. Or perhaps in our assisted living analysis we discussed previously, that this waiver bed is no longer going to be available. Under those criteria, in these statutes, there must be at least a 90-day termination prior to such termination. What if they're saying, well, we're not going to be in Medicaid any longer, and so you're all private pay? Even if you're on a licensed nursing home and you are not accepting Medicaid, so you have no provider agreement, you have to provide the residents before admission with a specific written notice that this home is not a participant in the Medicaid program. Therefore, you may be discharged if you're unable to pay for services. That has to be in your notices to the resident prior to admission. But without that, the assumption is that they do accept Medicaid. What is the remedy? A resident has a cause of action for breach of any duty imposed by this section and may be commenced by the resident by the filing of a civil action in common pleas, seeking injunction to prohibit the discharge and attorney's fees. So this has been a debate that has come up in our office about, is it 30 days or 90 days? Our advocacy has been that it requires 90 days if you're going to discharge a resident because you're going to renovate the rooms or no longer accept Medicaid. All right, our final slides about our helpline and our Mid-American Pension Rights Project, which is assists residents with finding pension or resolving pension issues. And then, of course, our Senior Medicare Patrol, which are volunteers that educate residents on Medicare frauds and scams. And then, of course, our private referral service. Thank you, everyone. Any final questions?
No final questions in the chat.
All right.
I think
So,
we're good.
all right. Thank you, everyone. And we are right at time. I appreciate everybody joining us. Again, our next set in the series will be on nursing home litigation, where we will talk some of these affirmative actions, as well as defending against the nursing homes lawsuits. We sort of highlighted a little bit of that today, but join us again May 10th at 10 a.m. Thank you, everyone.
Thanks, everyone. Thanks, Miriam. Bye.